Obligations and Contracts Title 1. Obligations Chapter 2. Nature and Effective Obligations to Give Article 1163. Every person obliged to give something is also obliged to take care of it with the proper diligence of a good father of a family, unless the law or the stipulation of the parties requires another standard of care. Standard of care required for things to be given. General rule. The standard of care required of the person who has the duty to give a determinate object is that of the proper diligence of a good father of a family. Exception. Unless the law or stipulation of the parties requires another standard of care. However, in case of a contrary stipulation by the parties, such stipulation should not contemplate a relinquishment or waiver of the most ordinary diligence. Example of another standard of care. Extraordinary diligence exercised by common carriers. Common carriers are persons, corporations, firms, or associations engaged in the business of transporting passengers or goods or both. Two kinds of things determine it: an object definite, known, and has already been decided and particularly specified as the matter to be given among the same things belonging to the same kind, e.g., an apple with attorney, Mill's autograph. Indeterminate or generic, any object belonging to the same kind, e.g., any normal apple. Article 1164. The creditor has a right to the fruits of the thing from the time the obligation to deliver it arises. However, he shall acquire no real right over it until the same has been delivered to him. Rights before and upon delivery of the thing. Before delivery, creditor has a personal right over the thing. A personal right is the power of one person to demand of another, as a definite passive subject, the fulfillment of the protestation to give, to do, or not to do, such right which is enforceable only upon the debtor who is under an obligation to give. If the creditor is prejudiced by the acquisition of an innocent third party, the creditor can go against the debtor for damages. Upon delivery, creditor has a real right over the thing. A real right is the power belonging to one person over a specific thing, without a passive subject individually determined, against whom such right may be personally exercised. Such right which is enforceable against the whole world and will prejudice anybody claiming the same object of protestation too. If an innocent third party is prejudiced by the acquisition of the creditor, the innocent third party can go against the debtor for damages. Article 1165. When what is to be delivered is a determinate thing, the creditor, in addition to the right granted him by Article 1170, may compel the debtor to make the delivery. If the thing is indeterminate or generic, he may ask that the obligation be complied with at the expense of the debtor. If the obligor delays, or has promised to deliver the same thing to two or more persons who do not have the same interest, he shall be responsible for any fortuitous event until he has effected the delivery. Remedies of non-delivery of the thing. Determinate thing. Action of specific performance. An action to compel the debtor to make the delivery, and damages, if the non-delivery is accompanied by the debtor's fraud, negligence, delay, or breach of contract. Indeterminate thing. The creditor may have it done or delivered in any reasonable way, charging all expenses of such fulfillment to the debtor. Thus, the creditor has the right to have somebody else to perform the obligation and the right to charge the expenses thereof to the debtor. In case of fortuitous event. General rule. Debtor is excused if non-delivery of determinate thing was due to a fortuitous event. Exceptions. A. If the debtor delays. B. If the debtor has promised to deliver the same thing to two or more persons who do not have the same interest. Thus, 1. The obligor may be liable for damages too, or will be bound to replace the lost object if the obligee agrees. Article 1166. The obligation to give a determinate thing includes that of delivering all its accessions and accessories, even though they may not have been mentioned. In short, Obligor is mandated by law to deliver the whole thing to do and not to do. Article 1167. If a person obliged to do something fails to do it, the same shall be executed at his cost. This same rule shall be observed if he does it in contravention of the tenor of the obligation. Furthermore, it may be decreed that what has been poorly done be undone. Article 1168. When the obligation consists in not doing, and the obligor does what has been forbidden him, it shall also be undone at his expense. Non-accomplishment of the act in a prestation to do. The debtor shall always be liable for the cost in the following instances. 1. When the debtor fails to do it. 2. When the debtor contravenes the tenor of the obligation. 3. When the debtor poorly fulfills the obligation. 4. When the debtor does what is forbidden at his cost. In the article both means 1. The right to have somebody else perform the obligation, and 2. The right to charge the expenses thereof to the debtor. To give, to do and not to do. Article 1169. Those obliged to deliver or to do something incur in delay from the time the obligee judicially or extrajudicially demands from them the fulfillment of their obligation. However, the demand by the creditor shall not be necessary in order that delay may exist. 1. When the obligation or the law expressly so declare, or 2. When from the nature and the circumstances of the obligation it appears that the designation of the time when the thing is to be delivered or the service is to be rendered was a controlling motive for the establishment of the contract, or 3. When demand would be useless, as when the obligor has rendered it beyond his power to perform. In reciprocal obligations, neither party incurs in delay if the other does not comply or is not ready to comply in a proper manner with what is incumbent upon him. From the moment one of the parties fulfills his obligation, delay by the other begins. Demand. A demand makes an obligation become due. Demand is needed only when the obligation is to do something other than the payment of money. In the payment of money, the time defaulted is compensated for by interest. 2 kinds of demand: extrajudicial and judicial. A commencement of a suit is a sufficient judicial demand. Delay, or default, as contemplated in this article, means delay with fault or negligence. If it is delay by mere inadvertence, the obligor will not be held liable under Article 1169. Article 1170. Those who in the performance of their obligations are guilty of fraud, negligence, or delay, and those who in any manner contravene the tenor thereof, are liable for damages. Rationale for Article 1170. The compliance with an obligation must always be done in good faith. Need for demand and delay is irrelevant. Here there are 4 causes provided by law which bring forth a suit for damages. 1. Fraud. 2. Negligence. 3. Contravention of the tenor of the obligation. And 4. Delay. If a fortuitous event occurs after any of the causes above, and in effect aggravates such causes, the obligor cannot be excused from being liable on the obligation. Article 1171. Responsibility arising from fraud is demandable in all obligations. Any waiver of an action for future fraud is void. Article 1172. Responsibility arising from negligence in the performance of every kind of obligation is also demandable, but such liability may be regulated by the courts, according to the circumstances. Article 1173. The fault or negligence of the obligor consists in the omission of the diligence which is required by the nature of the obligation and corresponds with the circumstances of the persons, of the time and of the place. When negligence shows bad faith, the provisions of Articles 1171 and 2201, paragraph 2, shall apply. If the law or contract does not state the diligence which is to be observed in the performance, That which is expected of a good father of a family shall be required. Cause. Fraud. This implies fraud committed after two parties agree to a contract, and not one which occurs to deceive a party into agreeing for a contract. Other characteristics. It is demandable in all obligations. Any waiver for an action of future fraud is void. Negligence and omission of diligence which is required by the nature of the obligation. Subjective. Limited by the circumstances of time, nature, and place. Liability is judged by these circumstances. Other characteristics. Presumption of diligence is that expected of a good father if committed with bad faith. Provisions of Article 1171 and 2201. 2. Apply. Bad faith is a state of mind affirmatively operating with furtive design and some motive of ill will. Not equated with an honest mistake, but a design to mislead another. Contravention of tenor of obligations. See Article 1166 to 1168. Delay. See Article 1169. Article 1174. Except in cases expressly specified by the law, or when it is otherwise declared by stipulation, or when the nature of the obligation requires the assumption of risk, no person shall be responsible for those events which could not be foreseen, or which, though foreseen, were inevitable. Fortuitous event. An act of God, an accident due directly and exclusively to natural causes without human intervention, which by no amount of foresight, pains or care, reasonably to have been expected, could have been prevented. Applicable only to determinate things in case of obligations to give. In case of fortuitous event on generic things, the creditor can simply ask for another copy of the thing. Does not serve to extend the contract. General rule. Fortuitous event excuses an obligor. Exceptions of the FF. 1. When there is fraud, negligence, delay, or breach of contract. 2. When there is an assumption of risk in the nature of the obligation. 3. When the contract provides that a fortuitous event will not excuse the obligor. 4. Other instances provided by law. Insurance contract, because its very nature involves the assumption of risk. Requisites of a fortuitous event. 1. The cause of breach of obligation must be independent of the will of the debtor. 2. The event must either be unforeseeable or unavoidable. 3. The event must be such to render it impossible for the debtor to fulfill his or her obligation in a normal manner. 4. The debtor must be free from any participation in, or the aggravation of the injury. Article 1175. Usurious transactions shall be governed by special laws. Article 1176. The receipt of the principal by the creditor without reservation with respect to the interest shall give rise to the presumption that said interest has been paid. The receipt of a later installment of a debt without reservation as to prior installments shall likewise raise the presumption that such installments have been paid. Presumptions of payment. These presumptions are overturned by strong proof to the contrary. 1. Receipt of principal payment. Presumption that interest has been paid. 2. Receipt of last installment. Presumption that all previous installments have been paid. The receipt of the last installment should refer to the specific date of the last installment. Article 1177. The creditors, after having pursued the property in possession of the debtor to satisfy their claims, may exercise all the rights and bring all the actions of the latter for the same purpose, save those which are inherent in his person. They may also impugn the acts which the debtor may have done to defraud them. Other remedies for the creditor. The following successive measures must be taken by a creditor before he or she may bring an action for rescission of an allegedly fraudulent sale. 1. Exhaust the properties of the debtor through levying by attachment and execution upon all the property of the debtor, except as such exempt by law from execution. 2. exercise all the rights and actions of the debtor, save those which are personal to him. Actions abrogatoria. 3. Seek the rescission of the contracts executed by the debtor in fraud of their rights. Action Pollyanna. Article 1178. Subject to the laws, all rights acquired in virtue of an obligation are transmissible, if there has been no stipulation to the contrary. Transmissible rights general rule. Rights acquired in the virtue of an obligation are automatically transmissible. Real rights are usually transmissible, while personal rights are not exceptions. 1. If there is a law or stipulation in the contract to the contrary, and 2. The owner of the right cannot transfer rights greater than what he or she possesses to the transferee.